Hi there, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments today. My focus is going to be on you today and your questions. So I don't have any particular topic today. I just want to hear from you and hear what questions you have about the immigration process. It can be anything that's immigration related. Just put those questions in the comments and I'll go ahead and answer. So while you're thinking of your questions or while you're typing your questions in, I'm going to go ahead and tell you how to get in touch with me should you have any questions about your particular matter. Because remember, the information I'm giving you today and the answers to the questions are based on general information. It is not particular legal advice. So if you're currently going through a matter, you're ready to go ahead and move forward, that's where you should definitely call, schedule an appointment to determine whether you qualify, and then we get started right away. But in the meantime, I want to hear from you and hear what your questions are. So go ahead and ask your questions. As long as I'm here, I'm going to answer those questions when I see them. Now, in order to get in touch with me, hi there, Caroline. It's nice to see you. In order to go ahead and get in touch with me, if you'd like to schedule a personal consultation, you're going to go ahead and use the number that's going across the screen, or you can go to the link that's in the description of the video to go ahead and contact us. I have multiple options to get in touch, and it's very easy. The first is you can always schedule your own appointment by clicking on the link, or you can call the phone number, the office, and the scheduling coordinator will be available to help you to schedule an appointment. But now that I'm here, go ahead and put your questions in the comments, and I will go ahead and answer. All right, so while I wait for your questions to come in, I'm going to give you a quick rundown on ways to stay in the United States and to get legal status, even if you have already overstayed your visa, or in some cases, even where you've crossed the border without permission. I'm going to do a quick rundown, and if any one of these situations fit what you're going through, go ahead and schedule that appointment and we can talk more in a more confidential setting because all my consultations are confidential. Now, there are different ways just depending on the situation. But for example, if you have a US citizen or, US citizen or legal permanent resident, spouse, a parent, or a citizen's son or daughter, and they've been mistreating you, even if you're out of status, and yes, even if you've crossed the border without inspection or you've come into the country without inspection, you're able to obtain work permit, special VAWA status, as well as your permanent residence in the United States, and you get to stay here. So I know maybe some of you have already looked into this type of situation, right? Where you're here, you overstayed, or you even cross the border without permission. And you may have been told there's no way to fix that situation. Well, I'm here to tell you that if you have been mistreated by any of the relatives that I just mentioned, that could be a way where you stay and apply for your own process. This is your own process, it's confidential. So that's one way, and it's called VAWA. And VAWA is for children who are under 21 and unmarried. It's for parents who are parents of citizens who have been mistreated by the citizens. And the citizens have to be age 21 and up. And it is for spouses of US citizens and residents. So even as the spouse of a permanent resident, even if you're here overstayed or you have come into the country without inspection, you're able to apply for VAWA relief should you qualify. And this is mainly based on the mistreatment or extreme cruelty by that relative. Now, there are other types of situations that undocumented individuals face in the country, and that's abuse. Certain abuses do rise to the level of trafficking. And so you may feel as if you're out of options here, and even other attorneys have possibly told you that you're out of options here when that may not be the case. If you have been abused, used, and abused by an employer, the employer paid you little and nothing, and this is just one of them. Even if the employer paid you well, but the employer, you felt as if the way the employer treated you made you afraid to leave. Maybe the employer even threatened to call ICE, or the employer told you that if you left, they're going to ruin your life, or they're going to get you deported because you're obligated to stay in the job, or the employer proposed that you perform acts that you did not want to perform. I have heard from clients who have told me that, for example, H-2B workers are often subjected to demands for sex by their supervisors in the United States in order to keep their jobs or to keep coming back to work for the employer on the H-2B. That can also be under not only labor trafficking, but sex trafficking. So if you're here now, you have been through the situation where you've gotten an H-2B or any other type of visa, or you've not had a visa, and you have found yourself in a situation where the employer attempted to get you to do this. So even in this case, you may not have done it. You may not have given in to their demand for sex, but they attempted to do that in exchange in exchange for something of value, which would be the job. That could potentially qualify you here as a trafficking victim to get the T status. With the T status, once you're approved for the T status, it means that you do get 4 years and a work permit to live here. Your relatives get the same status. Relatives include your children, your children who are under 21 and unmarried, your spouse. If you're under 21, your parents, as well as your sibling who is under 18 and unmarried. So this not only serves as a great benefit for you, coming out of that bad situation, of course, but also to your family members that may be in the same situation. And if they're outside of the United States, they get to come into the country with a T visa to join you here in the US. And then after some years, so 3 years, you're able to file for your green card. And in some cases, under certain scenarios, of course, we work with our clients to get the green card earlier, should they qualify. So you don't have to be in status to get this T status. So if you faced abuses like this, then just know that you could qualify for relief. There's also a provision, it's called Section 245I. Under 245I, if you had a previous filing on or before April 30th, 2001, and that filing, you could have been a derivative or you could have been the primary applicant, and say the filing never went through, or say just, you don't know what happened to you, but you were on filing, then you were in the United States, then you could potentially qualify without having to show your legal entry. So usually, other than VAWA, and other than being the immediate relative of a US citizen, the spouse, the parent, or the citizen's son or daughter under 21 and unmarried of a citizen, if you are fall into those categories, VAWA and then the immediate relatives of citizens, it doesn't matter that you overstayed your visa. However, you can still apply for adjustment of status. However, if you came into the country illegally, if you're not applying for VAWA, then you would have to fall under the Section 245I exception. So that's what I'm talking about. If you had a filing in 2001 or before, and on certain circumstances, you would have to be in the US, in the United States to qualify at that time. You don't have to show that legal entry. So I know I'm throwing a lot of information at you, but I'm telling you, giving you some good pearls here, because if you fall within these categories that I'm listing, you could potentially fix your status without leaving the United States. So, and then also as a victim of a crime, a qualifying crimes, for example, stalking, if you're the victim of stalking, domestic violence, assault, robbery, any crime that resulted in your physical or emotional abuse could qualify you as a victim of a crime. And so, if you're the victim of a crime, while the processing time for this visa is long as 5 to 7 years, right now, they have implemented a system where they issue, as long as you've properly filed your application, you will get your work permit and you'll be placed in deferred action, like a kind of protected type of status. It's not an official immigration status, but it's sort of like you're put in a protected category where they do not take action against you, so they don't deport you, and you get to stay here to wait for the U visa, and then also to go on to get the green card after you get the U visa. So that deferred action will be renewed. Now I'm seeing questions come in. So I'm going to go ahead and just jump into those questions, and then I'm going to call it a day. But know that I'll be back tomorrow where I'll answer your other questions tomorrow, and I'll bring a topic for you. How long does VAWA take? So the whole process takes about 2.5 years. But keep in mind, this is your process. So you're not dependent on someone who is potentially abusing you or mistreating you. Another thing is that you do obtain the work permit and your travel document halfway, about 6 months into the process to a year through the process. And that gives you some stability, it gives you the ability to work and, build your own life here, get a head start on life while you wait for the entire process to be completed. How long is the wait typically for the I-485 after you submit your RFE for I-693 after your I-130 is approved? So, it depends on the service center. You could be looking at a few months more, so weeks to months. It just depends on how quickly the office is moving. Um, what are the steps involved in the asylum and withdrawal of removal process? Will we be detained during the process? So I don't know what your situation is now. Where are you now? Usually, if you got a notice to appear, um, and they have not detained you yet, then there's I don't know what your risk factor is. I don't want to say your risk of being detained is zero, but if you've just gotten a notice to appear, the chances of you being detained is low unless they identify a threat or that you will flee or not carry through with the court process. However, there are two ways that this can go, right? You can get the notice to appear and continue to attend court hearings. And you may be required to sign up with ICE or check in with ICE, just to make sure that you're complying. And then the other is detained, and then you attend the immigration court hearings as a detained individual. But usually, when you're attending the immigration court hearings as detained, it usually starts with you being detained and then they put you through the process. You don't get the notice to appear and then get detained unless, of course, something changes that they feel they need to detain you. So with asylum, withdrawal of removal, it just depends on, do you qualify for asylum? Do you fear going back to your country? Do you have a valid claim? With withdrawal of removal, that withholding. So I think you mean withholding of removal. And I did obtain a withholding of removal for my client because we proved that even though he did not qualify for asylum, if he was returned to his country, he faced a likelihood of being harmed or even killed in his country. And so he got withholding of removal in the alternative. Um, so, what you should do, these are, especially with the immigration court, it's if you have no knowledge of the law, it's very hard for you to formulate a great defense for yourself. I highly, highly, highly urge you to invest and get you an attorney. I can definitely speak with you about what you're going through and determine whether I can represent you through the process. Can you travel with a travel waiver, or is it highly not recommended? Yes, no, if you're talking about ESTA, you can travel. You have to sign up, register beforehand, and they'll let you know whether you are good to go through on ESTA. Now, when you do travel on ESTA, you have to make sure you're very compliant with it because they're very strict on that 90-day timeline. And if you end up going over that 90-day timeline, it could mean problems for your travel in the future. Now, I want to visit family and have the travel parole document, but I've heard many sources that it isn't recommended. So I wouldn't be able to tell you though. So since you've given me more context here, the travel document, I advise my clients on an individual basis about those, just because it really is on a case by case basis. So you have to be very careful about it, and the advice is going to differ just based on your particular situation. If your spouse died before the papers are submitted, is there anything that can be done surrounding that situation? It's going to depend on the spouse. If you have a U.S. citizen spouse, then yes, you can then petition for yourself, and we help our clients to do that. So go ahead, give us a call, and we'll talk through your situation. You usually have 2 years to do this, and your children can be included in that self petition. So it's a self petition based on the death of a U.S. citizen spouse. Give us a call, and we can help you. All right, that's going to be it for me today. Thanks everyone for your time. I'll be back tomorrow with a topic, and then you come with your questions. I will go ahead and talk to you tomorrow. All right, bye bye.